As the parties have noted, there are certain statutory and common law concerns the court must address, at least consider, in imposing sentence. Under 13 BSA Section 7030A, the court must consider the nature and circumstances of the offense, the history and characteristics of the defendant, defendant's family circumstances and relationships, if those are relevant, impact on defendant's children, not really been addressed as an issue, the need for treatment, non-compliance with court orders in the past, risk to others and the community. And the common law factors are generally punishment or retribution, are terms that are used, specific and general deterrence, and rehabilitation, if that is a consideration. There's overlap in all of these concepts, but I think it's fair to say most dramatic in this case, which shapes much of the sentence I will impose, has to do with the nature and circumstances of the offense, with consideration to the history and characteristics of the defendant. In other words, rehabilitation is not going to be a primary piece of this sentence, although the court is hopeful that Mr. Ferlazzo continues to do to adjust well in his environment and does present a good example for others who are in there. I want to begin by saying the obvious. Emily Ferlazzo had a beautiful, beautiful voice. And I'm not just referring to her singing, which we heard here today, which was great. It's Leonard Cohen's song. It's a beautiful song. But it's also clear from listening to the extraordinary impact statements provided by the victims here today that it extended to all areas of her life. It was a voice that deserved to be heard. It was a voice that deserved to grow, to mature, and if necessary, to heal. And it deserved to do that for a long, happy life. That very sadly was cut short by her murder on October 16, 2021. And it was cut short at the hands of Joseph Ferlazzo. So that is a segue into looking at the nature and circumstances of this case. This is an horrendous crime. It is an act of cruel and extreme domestic violence that the jury clearly found not only failed entirely to make out self-defense, but lacked any provocation that might reduce the crime to second-degree murder or voluntary manslaughter. And the court fully finds that it was a crime that was premeditated and deliberate. So it is an appropriate case for consideration as a first-degree murder conviction. The circumstances of the crime, and I think, and I'll get to Mr. Ferlazzo's statement to the court today, while there were certain things where a little bit more openness in that statement, there was also a recognition in the statement that perhaps the fight that led to the murder was this fight about whether Emily was going to turn him in for unprofessional conduct that she felt he was doing. And that he saw his livelihood or things like that. That's certainly something he shared with police in giving his statement. And it may have been more complicated. There may have been other things going on. But clearly that sense of I might leave you, or this is something that I can't live with anymore, in terms of what she considered unprofessional conduct, seemed to be a precipitating or part of the precipitating events that led to her murder. The statement given by Mr. Ferlazzo to police, as the court has pointed out in its written findings relative to the motion for judgment of acquittal and for a new trial, and stated in part already today, was an extraordinarily complete statement in many respects of Mr. Ferlazzo's involvement in Emily's death. It was a statement that, in the court's consideration, was voluntary, done pursuant to excellent police procedure, and a statement he wanted to give at the time. And he did give. It is a statement in which he fully confessed to having whatever the buildup was. And there are many things still in that statement and testimony regarding hitting with a Yankee Candle and things like that, which there is no corroborating evidence, and frankly, without that, the court does not find it. The court there was no evidence of bruising. We saw what Mr. Ferlazzo's body looked like through pictures introduced at trial. There was no evidence of scratches. There was no evidence of marks. There was nothing. So whatever occurred seemed to be connected to what Dr. Powell said, a tumultuous relationship that they had. And it's certainly clear that they did. And the exact who did what to whom under what circumstances is really not something the court has a clear idea of. There wasn't clear testimony on it. There certainly was some on each side. But the fact that Mr. Ferlazzo did as he said, which is after sitting for whether it was 5, 10, 15 minutes percolating, feeling this heat, this wave, he picked up a gun with a silencer out of the closet, got over Ms. Ferlazzo, straddled her. She said words to the effect, you got to be fucking kidding me. And he put the pillow over her head and shot her twice in the head. And that is what he said to police. And what's equally important is that is what the evidence showed in the aftermath, that this wasn't something that he was feeling badly and just wanted to take responsibility for something he didn't do. It was something that was clearly confirmed through the police investigation thereafter. The pillow was there with the shots, the blood, the fact that the head was against pillows was confirmed by Dr. Shapiro with the exit wounds that showed that this was not a case where she was lifting up and then fell back down. So the evidence he provided of the murder itself, the Taurus is found under his pillow. Not the Taurus, the Glock is found underneath his pillow. There is no Taurus found on the bed. The Taurus, I think, is in a kitchen drawer when police come in thereafter. So these are all facts which Mr. Ferlazzo provided to police, which are clearly consistent with the police investigation thereafter. He then discusses what he did in great detail with the brunch at Misty's, what he said and how he lied to his sister repeatedly, how he lied to the Langs, how he, the conversations he had with the Basses when he goes there on Monday night, all of which are intended, it would appear, to throw folks off from determining that he did it. The aftermath, when we're looking at the circumstances of this offense, the aftermath of the murder is something that sets this case significantly apart. While provocation was completely unjustified here, leading to the murder, and this is a sad comment, murders by people who explode in a short period of time occur. There are other cases with a longer period of time of planning and things like that. If it had ended there, the court would have to view it one way, but it didn't end there. Every step taken in the next 3 days are steps that have rarely been seen before. And this is intercepts somewhat with Mr. Ferlazzo's testimony, because what happened and what he admitted to police, obviously, is that he had not only put up a plastic bag over Emily's head so she wouldn't bleed too much on the bed, but that he then, he thought it was early afternoon that day, whether it was or not, that there does appear to be a time in there, since he seems to go up towards St. Albans at about 12:03, and he's starting the tattoo of his sister maybe at 3 o'clock that day, so there is a window then. There's no other window that I know of in the day, given the tattoo, then dinner, and then the campfire on that night. But he dismembers her body as described by him, and then as found, says he puts them in black bags that are in the shower, and indeed that's where they are. Again, details, police were clearly didn't know that detail when he gives that statement. And he clearly tells them where it is, and he accepts that he has done that. What is interesting, and I'll talk about this a little bit more, I don't exactly know what to make of it, but even in this statement, and certainly in the trial and in the entire aftermath of what's going on, I think Ms. George used the word detachment. There is a detachment that appears to allow him to have a nice meal with his sister within 8 or 9 hours of having killed Emily. A detachment which allows him to have the steadiness of hand to do a tattoo over the course of 3 hours, and then to engage in more time with his sister, and then friendly conversation by the campfire that night. A detachment that allows him to go on Monday to the Bass house, break bread with them, and come up with a story both to them and I think it's Trooper Cody, about where his van is, where things are. But just, and then a detachment in the way he expresses things. I don't know what that's about. I'm not going to try here to figure that out, but it is an extraordinary event. So the factor of but what also was shown, and maybe by the dismemberment, maybe more by the 18 stab wounds post-mortem, is that there's an incredible rage that has never been discussed. What's going on in Mr. Ferlazzo? And when the state points to the fact that now there's amnesia about this, whether that's an accurate statement or not, we don't have a clue how that rage is being processed, how he is dealing with whatever it is he did. Because instead, we got a statement now that subsequently that this is in self-defense, and I don't really remember anything I told police. I don't remember dismembering the body that I talked so vividly about. I never introduced the stab wounds in my first statement, but I don't remember them or going to the Basses. That could be seen as quite convenient because it doesn't allow for real cross-examination of the event. But what the court can say with utter certainty, and this gets into the characteristics of the defendant to some degree that we'll get to, is that the testimony at trial was untruthful. And whatever the basis for that is, whether it's out and out lies, as the state understandably suspects, or it's some psychological piece that Mr. Ferlazzo can't accept, or something in between. The fact is that his testimony regarding how this offense occurred and the aftermath is not believable. And no, I don't know if I've ever seen a case, and I've been doing this for a long time in different capacities, where we're used to inconsistencies between witnesses. We're used to even very, very different accounts of events by different witnesses, and we have to say, gee, are they telling the truth? Are they lying? Did they see it differently? We do all those things we try to do to figure out what the truth is. I don't know if I've ever seen a case where the extraordinary inconsistency in statement is by the same person, and that the much more detailed statement is the first one, and the second one is the one that is vague and subject to amnesia. And that's why I asked the questions I did of Dr. Powell to see whether he'd ever seen anything where somebody had such clear recollection and then had very little, and what he did have was just vastly different. For example, a gun being under her pillow that wasn't ever there before, and certainly wasn't there when police came to do the search. And he said that suggested a lack of credibility even in that regard. So that is important on a number of fronts. The amnesia is important on a number of fronts. The inability to face what he did in one way or another, not only in the killing but after the killing, is important because it does go to a sense, does that present a risk if released? Now, the sentence the court is going to impose, whether it is going to be long enough that I don't think that's the major concern here, but I think it's well taken that unless this is dealt with, if he were to be in another relationship and didn't deal with that, there are risks. All right. Going further into the history, so in terms of the nature and seriousness of the offense, let me just say, together with the aftermath, and considering just how the aftermath exacerbated the pain and suffering of the family in this case, it's just an extraordinarily powerful piece. All of the impact statements were very important for the court here. Of course, Ms. Bass has summed it up in a way that provided what the court really hoped, which is to make Emily be a person of respect, of concern, of love, of care, and they did that very well. But it also showed just how painful living with the idea of imagining what was happening to your daughter when it's happening, imagining speaking with Mr. Ferlazzo, talking to them with a straight face about Emily leaving when he knew that wasn't the case. The pain that generates not only the day after when they learn of the murder, but every day since, it's extraordinarily powerful. Let's talk a little bit more about Mr. Ferlazzo. I have talked about, and there are characteristics which are of great concern that I've already talked about, and that is how he can behave in the way he behaved in the 3 days after the murder. What is that about that hasn't been challenged? Certainly Dr. Powell wasn't asked to comment on that, and I don't blame the defense for not. I think that makes sense. But clearly it showed a person who can divorce himself from emotion to such a degree as to continue to hide this horrendous act that he had done. But there are qualities that Mr. Ferlazzo does have, and life is complicated, and Mr. Ferlazzo, I'm sure, is complicated. He doesn't have a criminal record. He's an extraordinary artist. People love his tattoo work. Indeed, sadly, I think that's how Emily and he may have first connected, and certainly with some of the other women who provided reference letters for him. I'm not going to get involved with what the relationship was between Mr. Ferlazzo and those women. I will take them at their word that he provided some comfort for them. How he did it, whether it was on terms of it works for me as long as I'm your protector and you're listening to me, but not, that's beyond the scope, I think, of what the evidence showed completely in the case. Although I certainly understand the state's argument in that regard. So there are qualities that he has, and even the inmate, Mr. Morrow, who talked, he may not be the greatest guy in the world, but the fact that Mr. Ferlazzo can talk to him in a thoughtful way is, I can see how he can do that. He can talk thoughtfully. He can talk in ways that you want to believe also, whether they're true or not. And that's an issue that the court is battling with a bit. In terms of characteristics, so let's talk about the alcohol use. I think there is a certain convenience to bringing up alcohol use now because it is a mitigating factor, which obviously folks know about or can be a mitigating factor. I am thinking of, though, a case that's recent, State v. Schwartz, which was a first degree reduced to a second degree. And guy was clearly very, very drunk and shot his wife. The significant history of alcohol abuse and domestic abuse in that case that may not be present here, but the aftermath facts are not present there that are present here. But we heard at most that Mr. Ferlazzo in his trial testimony had a few Red Bulls and vodkas. In the statement to police, it was some vodka and some wine, and maybe smoked some pot. In the statement to police, it wasn't that big a deal. What is very clear, though, is, for example, there's almost nothing he drank between the hours of 3 o'clock on Saturday and midnight, when he did the tattoo, goes out for dinner without much, and then is sitting at a campfire and not drinking at all. So the description of him as a quote-unquote chronic alcoholic, I don't think he's ever described himself as that, but the court does not find that he is that. I also have in mind Ms. Bass's testimony at trial, where she didn't see drinking as being a significant event in the months that he lived there. That doesn't mean that he wouldn't be helped by addressing, and apparently has addressed, his alcohol use. But the court is, and whether it played any part in his response here, he did today for the first time acknowledge at least overreaction in his killing of Ms. Ferlazzo. He still insists it was all quick and of that nature, which I think is inconsistent with the testimony. But there's at least some acknowledgement he should not have done what he did, and a softening of the statement he gave in the pre-sentence investigation report, which again did do what I think Ms. George said. It sought to say, I had no choice. I had to do this or die, but I should have died. And again, it's a statement that portrays him more the victim and Ms. Ferlazzo more the perpetrator. And let me be very clear, there's only one victim in this case, and that's Ms. Ferlazzo. So the history and characteristics of Mr. Ferlazzo are mixed. There are certainly some strong pieces, and there are certainly some extraordinarily concerning pieces, given what we've learned through what he did after the event, which is, again, so troubling, without any recognition of why it would be so troubling. We still, to that day, haven't heard that. All right. In terms of other things, and again, I don't like to stress individual pieces. We have talked a lot about dismemberment and the stabbing and going to the basses. But the text messages that were provided and seemingly addressed to Emily, I don't know, 8, 10, 12, whatever number they were, ending with the one on October 18th with I don't deserve this shit. I mean, I don't know. Again, I'm not going to overplay that, but it's an extraordinary piece of that goes to this thought that I'm still the victim here. And you're going to have a long time to think about this. Think about what really happened here. I've heard there's a trauma history, and maybe there is. I haven't seen any. And one of the things you might want to do in unbuckling a trauma history is see how did that trauma result in my making a decision to end Emily's life. And instead I'm hearing still that it was more or less a case of self-defense, which is, so someday that might be something he can do. I assuming had a hard time. I don't have enough evidence here about trauma history to consider that in any kind of deep way from a mitigation point of view. So the mitigators are the lack of criminal record, the feelings of some folks of how important he was in their life. I think that those are real. But the aggravators are stronger, and here it is. She's lying in bed. She's 5 foot or 5'3". Mom thinks 5 foot. Some records said 5'3". She weighs 128 pounds at most. Some thought 120. Mr. Ferlazzo was in extraordinary shape. He's this strong, great-looking guy, and 6 feet tall. There's just no excuse. And the aggravators primarily include everything he did afterwards. Certainly the state is right. The court can consider United States v. Donegan is a 93 case in which if the court believes that a person is lying or significantly untruthful, that can be a basis to believe, and that's a U.S. Supreme Court case, that in fact there's continued risk to community. And in this case, again, I don't want to categorize it. I know Ms. Jantz has not wanted me to categorize it, but it's clear to the court that the testimony Mr. Ferlazzo gave here was not credible. It was not truthful. Every bit of independent testimony confirmed that. You know, I made reference to the falling back, but the cradling of Ms. Ferlazzo's body. And he did say maybe this was a dreamlike sequence. I don't know, but it was supposedly occurred Saturday night when he's at the campfire. And it also probably, if his testimony, at least his statements to Detective Orris are correct, was after he had already cut up her body. And we're not quite sure when that happened, but I thought that was his best indication that it was early afternoon. So these are all very complicating and aggravating circumstances in this case, because so long as he continues to think of himself as a victim, he's not going to progress very much in this regard. I will note that if he's not involved in an intimate relationship, there isn't a basis to think that he presents significant public safety concerns. So in balance, I have considered specific general deterrence. I don't think specific deterrence will be there, but mostly this is a punishment, nature and circumstances of the case sort of sentence with some reflection for his history and characteristics. I did note there are other sentences I have reviewed. Swartz was one of them. Ray is another one. Those are both second-degree murder convictions, although Swartz clearly was a first-degree type case. And without the extraordinary cover-up and the untruthfulness during trial, the court might have been inclined at a somewhat lower sentence. The court is not going to go as high as the state has asked, but it does believe a to-serve sentence is required. It does not believe the circumstances of this case are extraordinarily aggravated, and it also thinks some amount of time beyond the statutory minimum is appropriate, given the aggravating nature of the circumstances. So I will announce the sentence of the court at this time. The sentence of the court on the conviction for first-degree murder will be 42 and a half years to life to serve. I wish you luck. I wish this family luck and blessings in the secular sense of the term. I really, and Mr. Ferlazzo, there are things you can do good while you're incarcerated. Go about and keep doing them and live your life and try and see where you can grow as well. Thank you, everyone.
Judge, may I ask a question so my record for appeal is clear? Because the court has used interchangeably untruthful and not credible, and I do not see them as the same thing. Not credible means that you do not believe that a person doesn't believe the statements. Untruthful means a deliberate.
I don't think it does. I think it's just not true.
Well, not true and untruthful are the same, that the person is aware of the truth and is attempting deliberately to deceive.
I never used that term.
You used the term untruthful.
I did. I think you folks are going to have to look it up after.
I did, and I have.
And it says that I thought the testimony was not true, right?
Untruthful twice, but you've also alternated with not credible. And I just want to make sure for appeal purposes, which one.
I'm just saying they're the same thing.
Okay.
I'm saying they're the same thing. I am not getting into his psychological state as whether his intent was specifically to lie, which I think the evidence showed it might have been. I think there's good basis to do that, or whether he just can't live with what he did and has made up something which he may believe is true now. It just isn't true. And I think that is a aggravating circumstance, whether he's lying intentionally or just unable to face what he did.
I understand the court's explanation. For appellate purposes, though, if the court means that he is deliberately being deceptive, then I object to the court relying on that for sentencing for
Okay.
purposes.
Appreciate it.
Thank you.
Take care, everybody.